What is DNA evidence? DNA evidence is biological material, such as blood, saliva, skin cells, hair roots, or other trace tissues, analyzed for genetic markers and compared to a person's genetic profile to assess whether they could be a source of that material. In simple terms, it is a biochemical fingerprint that can powerfully include or exclude a suspect. That is the clean definition. The intrigue begins when we ask how something so authoritative can be used, misused, or overtrusted in ways that frame the innocent and make people whisper about a legal conspiracy. A quick origin story helps. Modern forensic DNA emerged in the late 20th century and quickly transformed criminal courts. Early cases showed its exonerating force. People wrongly convicted were cleared when biological traces did not match them. Courts, seeing both precision and promise, gradually treated DNA as gold standard science. But any gold standard can be tarnished by contamination, human error, statistical misunderstanding, and legal rules that amplify rather than correct those weaknesses. Start with contamination and secondary transfer. DNA is sticky. Skin cells shed onto doorknobs, clothing, or tools. Those cells can hitchhike via first responders, evidence bags, or shared surfaces, arriving where they never originated. Touch DNA, minute quantities from casual contact, can appear on objects a person never handled at the time of the crime. That means a match can be perfectly accurate about the biology and perfectly misleading about who did what and when. If crime scene handling is rushed, if gloves are reused, or if lab benches are not rigorously decontaminated, innocent DNA can seep into guilty places. Now consider mixtures. Many crime scene samples contain DNA from several people. Interpreting such mixtures is hard science layered with expert judgment. Analysts must decide which peaks in a chromatogram are true signals and which are noise, and whether alleles dropped out because the sample was too faint. Probabilistic genotyping software helps, but it introduces opaqueness. When the math is in a black box, defense counsel may struggle to test it. The result is a number, a likelihood ratio, or a probability that can sound crushingly precise to a jury, even though it rests on assumptions about degradation, dropout, and contributor count. If those assumptions are off, an innocent person can be swept into the mixture. Then there is the database effect. Investigators sometimes search large DNA databases and celebrate a cold hit. Statistically, searching thousands or millions of profiles raises the odds of coincidental matches. The danger is the prosecutor's fallacy, confusing the chance of a random match with the chance that the defendant is the source. Those are different probabilities. When courts and juries are not carefully instructed, a cold hit can be overvalued, turning a weak lead into a seemingly ironclad identification. Human factors loom large. Analysts are skilled professionals, but they are human. Cognitive bias can sneak in when analysts know the detective's theory, have seen incriminating photos, or feel institutional pressure to help the case. Blind or shielded analysis, where the scientist does not know which sample is the suspect's, reduces this risk, yet many labs still operate without robust blinding. Add case backlogs, budget stress, and performance metrics, and you get a recipe where subtle bias tilts borderline interpretations toward inclusion. Chain of custody is another fault line. Evidence must be tracked, sealed, and labeled from scene to courtroom. Mislabeling, broken seals, or sample swaps can invert truth. Because DNA tests can consume a sample, the defense may be left with nothing to retest, turning a single flawed run into an unreviewable conclusion. When bench notes, quality control logs, and validation studies are not fully disclosed, the adversarial process cannot do its job of testing the science. Legal doctrine can magnify these problems. Judges act as gatekeepers under reliability standards. But once DNA clears that gate, juries sometimes hear it as infallible. This is the so-called CSI effect. The spell of lab coats and charts can overwhelm common sense questions about collection, context, and contamination. Add rules that privilege proprietary software or limit defense access to source code, and courts may unintentionally enshrine a trust us model where scrutiny is thinnest precisely where it should be toughest. What about the conspiracy whisper? It is rarely a cloak and dagger plot. The more unsettling reality is structural. Overlapping incentives, institutional blind spots, and legal defaults that collectively tilt toward overconfidence. Police want to close cases, prosecutors want to present strong evidence, labs want to be seen as accurate and indispensable, courts want efficient proceedings. None of that is sinister in isolation. Together, it can create a current that pushes ambiguous DNA evidence towards certainty and certainty toward conviction. Examples make this concrete. Imagine a burglary where a tool bears a few cells from a resident who once lent that tool to a neighbor. Secondary transfer explains the biology, but the timeline is wrong for guilt. Picture a chaotic stabbing where DNA from multiple people mingles on a jacket. The software flags a contributor consistent with the defendant, yet a different assumption about contributor number flips the conclusion. Or consider a cold hit from a distant database. The match leads police to reinterpret ambiguous eyewitness accounts through a new lens, while alternative suspects quietly fall away. Each path is lawful, all can mislead. So how do we safeguard the innocent without discarding a powerful tool? Demand meticulous collection protocols and independent audits. Require labs to adopt blinding and to disclose validation studies, error rates, and analyst notes. Encourage courts to insist on transparent, testable software or, at minimum, meaningful defense access. Teach jurors the difference between source probability and activity probability. Not just whether the DNA could be yours, but whether it got there in the way the prosecution claims. Use caution with low template samples and complex mixtures. Sometimes the most scientific answer is restraint. A final curiosity. DNA is superb at answering whose. It is weaker at answering how and when. The law's task is to keep those questions separate. When we blur them, we do not uncover a conspiracy. We manufacture one against fairness itself. The antidote is daylight, discipline, and humility. Trust the science, but test the story that surrounds it. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.